If you're a regular listener of So to Speak, it's probably safe to say that you have an interest in the First Amendment. So you'll definitely want to check out the Foundation for Individual Rights in Education's First Amendment Library. The First Amendment Library is a free, ever-expanding online database of First Amendment-related materials, articles, and more than 900 Supreme Court cases. Among the unique features of the First Amendment Library is its collection of the complete transcripts of comedian Lenny Bruce's obscenity trials. This is the first time ever that these documents have been made publicly available for free online. The library also hosts the papers of famed UCLA law professor Eugene Volokh and features illustrated timelines of seminal events in First Amendment history, including a timeline for today's podcast topic, campaign finance. So to check out this one-of-a-kind resource about the First Amendment and its 5 freedoms, visit thefire.org or firstamendmentlibrary.com. Now on to the show.
Freedom of speech.
Fundamental rights.
Freedom of conscience.
Academic freedom.
Freedom of press.
And the right to listen.
You're listening to So to Speak, the free speech podcast, brought to you by FIRE, the Foundation for Individual Rights in Education.
Welcome back to So to Speak, the free speech podcast, where every other week we take an uncensored look at the world of free expression through personal stories and candid conversations. I'm your host, Nico Perino, and on today's show we're going to take a deep dive into the murky and often confusing waters that are modern campaign finance law. Even within the First Amendment free speech community, there's some disagreements about what kinds of campaign finance regulations pass constitutional muster. Attorney Martin Garbus, who we spoke with in December, for example, doesn't think money spent on politics amounts to constitutionally protected speech. And he thinks the United States Supreme Court's decision in 2010 in the Citizens United case was wrongly decided. Our guest on today's podcast, however, is on the other side of that spectrum. Sam Gedge is an attorney with the Institute for Justice, which is a public interest law firm based out of Arlington, Virginia, that regularly challenges campaign finance restrictions in court. Perhaps most famously, IJ co-litigated the seminal SpeechNow.org v. FEC case, where in 2010, the United States Court of Appeals for the District of Columbia held that limits on contributions to political action committees making independent expenditures are unconstitutional. This was the case that allowed for the creation of the so-called super PACs. Sam is a graduate of Harvard Law School, and before joining the Institute for Justice, he practiced election law at Wiley Rein LLP in Washington, D.C. He also clerked for a judge on the U.S. Court of Appeals for the 8th Circuit. Sam is involved in litigating many of IJ's campaign finance lawsuits, and on today's show, he is going to tell us about some of those cases. But because campaign finance law can be so complicated, even for the most experienced of attorneys, I wanted to spend most of this podcast going over the basics of campaign finance regulation. For example, what laws exist at the state and federal levels, what are the most common arguments for and against restrictions on political expression, what are the major cases, and what does the future hold for campaign finance in the era of Donald Trump? This podcast will be more or less a campaign finance for dummies podcast, if you will. And before we begin, full disclosure, I worked at the Institute for Justice for about a year or so, from 2014 to 2015. And I wanted to get that out of the way before we began here. Now, with that out of the way, let's dive into those aforementioned murky waters. All right, Sam, thanks for coming on the show. I appreciate you taking the time to talk to me today.
Appreciate it.
Yep. So let's get started here by just setting the landscape for our listeners. What sort of campaign finance regulations exist in the world? And let's look at it from a federal level and a state level. What does the federal government do to police speech or participation? I don't want to get into speech yet, but participation in elections.
Sure. Well, you're right that what we're talking about here is speech, even though we use these technical terms like campaign finance. But at the federal level, what we're talking about is restrictions on what kind of political messages people can spend money on, who people can associate with, who they can give money to, as well as more recently, we've been seeing increasing disputes over disclosure obligations. If you get involved in a political campaign, what do you need to disclose about yourself or about the people that you're associating with.
So there's a number of ways then that people can participate in electoral politics other than running for office. So you said direct contributions to candidates is one. They can give to these 501c4 groups. There's a lot of debate surrounding what those groups do and their influence on elections. But they can also create PACs or join together with other people to speak about these issues. Can you go through these one by one? So what are the limits right now if me, Nico Perino, want to contribute to federal election?
Sure. So when we're talking about actually giving money to a candidate, I think at the federal level, it's something like $2,600 a year. That might be a little bit off. But more importantly, if you want to go out and spend money on your own or give money to someone else who wants to go spend money on their own, you're not subject to any limits. So the technical term is like independent expenditures or electioneering communications. The groups that engage in this kind of speech are super PACs, which the Institute for Justice litigated into existence a few years ago.
The Speech Now case from 2010.
Exactly. That was at the D.C. Circuit, right?
Yeah, and that came around the same time as Citizens United. What's the difference between, for our listeners, the difference between Speech Now and Citizens United?
Right. So, Citizens United, of course, famously said that the government doesn't have the right to stop people from spending money to talk about politics. And what the Speech Now case at the D.C. Circuit held just a couple of weeks after that was that, okay, well, if we can't stop someone from spending their money to talk about a candidate, we can't stop other people from joining together with that person to talk about candidates. Essentially, if one person can speak independently about politics, why can't a group of people, a group of neighbors, for example, pool their resources and engage in that kind of activity?
And the spending that they're doing here and the spending that the courts considered are called independent expenditures, right? And that's sort of a jargony term in the campaign finance world, but for our lay listeners, what does that mean?
Sure. So independent expenditures is a technical term. Essentially, it means that we're talking about speech. We're talking about political advertisements, newspapers, or TV ads that contain what are called magic words. Vote for candidate X, vote against candidate Y. Kind of classic, explicitly electoral speech.
Mm-hmm. And are these independent expenditures coordinated with the campaign in any way?
No. So the independent part of the term is that they are independent. The thinking being that if you have an outside group that's working with a candidate to run ads helping that candidate, that's really no different from just giving the candidate money to run the ad himself.
So you're giving the candidate money, and there are limits on that. But when you're not giving the candidate money, but you're talking about an election independent from coordination with that candidate, that's an independent expenditure. And there isn't limits. There aren't spending limits.
That's exactly right. Ever since Citizens United, nationwide, you can spend as much as you want talking for or against candidates.
And now let's get into this other question that you brought up about disclosure. So you can spend the money. The next question is, do other people in society have a right to know that you're spending this money? And how does the federal government right now draw a distinction between when you need to tell the world essentially or disclose when you're spending money on politics and when you're not required to?
Right. So it's an incredibly Baroque system. But briefly, it really, the amount of disclosure that you have to engage in depends on what kind of speaker you are. So if you team up with a bunch of people and you pool your money to run an ad against a federal candidate, for example, you might have to disclose all of the money that goes into that. The thinking being that you've all kind of contributed explicitly with the goal of running this particular ad. If by contrast we're talking about a corporation like Coca-Cola, for example, wants to run an ad, they don't have to disclose everybody who's bought a can of Coke in the past year or two. It's a corporation, it's their own general treasury funds. They probably won't be disclosing people the funding sources that they used.
Mm-hmm. But so if you're a super PAC, for example, you do need to disclose.
Exactly. So a super PAC is just a fancy word, basically, for a group of people that join together with the major purpose of trying to influence federal elections. I think super PACs kind of get a bad rap. It's a bit of an unfavorable term, but really that's what we're talking about. Just a group of people, or that might create a corporation, or just act as just an unincorporated association who want to put together their money and put out an ad.
And you see a lot of discussion surrounding this term dark money. So this is a way to contribute to a campaign, either directly or indirectly, depending on what your motives are, through contributions to 501c4 organizations. These are nonprofits that are also allowed to engage in political activity so long as the majority of their activity is apolitical. These organizations aren't required to turn over their funding sources to the federal government.
Typically not, that's correct. So these are groups that may do a ton of things that have nothing to do with elections, but some of their spending might have to do with running an ad, speaking for or against a candidate.
Sierra Club, for example.
Exactly. I'm not sure if they're a C4 or C3, but assuming they have like a political advocacy arm, that they might well qualify. And when it comes to speech by those kinds of organizations, the campaign finance laws don't require them to disclose all of their donors. The thinking being that someone could have given money to the Sierra Club because they just care about the environment generally, or they want to help a particular environmental cause, not that they want to support or oppose candidate X, who the Sierra Club just happens to run an ad against.
Yeah. The argument on behalf of the reformers, though, is that this is a vehicle by which really rich billionaires, for example, can give money to a nonprofit organization that can then use that money to support a political candidate.
Right, that is the argument. I'm not sure how often that becomes a reality, but I think that goes to a more fundamental disagreement about, why are we conditioning people's right to associate, to exercise their free speech rights on having to divulge, their name, their political affiliation, their sympathies, their home addresses in some cases. That, I think, is the core disagreement when it comes to disclosure laws today.
And you and I, Sam, we were talking before we started recording this podcast about freedom of association issues, and there was some litigation surrounding this even before the major Buckley v. Valeo decision in 1976 that we can get into. But, in 1958 in NAACP v. Alabama, right?
That's exactly right. And I mean, I think the NAACP cases in the 1950s were a very dramatic example of how compelling people to disclose their associations really could chill association, chill speech. I mean, there was serious violence going on back then. I think the principles, though, have similar application when it comes to just association, political speech, political association more generally, even in 2017. There's no question that lots of people are sensitive about disclosing on the internet, who they support politically, who they oppose politically, much less, what their address is, what their name is, who their employer is. But at the federal level, at the state level, very often that's a condition for someone who wants to contribute a very little amount of money to a group, for example, that wants to run a political ad supporting or opposing a candidate. Yeah.
You mentioned state level. So we talked just now about federal regulations of campaign finance or support for candidates by their supporters or by their detractors, because you can also spend money on politics in opposition of to people, or even not in opposition, just as a form of journalism, which was at issue in Citizens United. Of course, the facts there were that this organization, Citizen United, wanted to create a movie about Hillary Clinton leading up to the 2008 election, and federal regulations at the time said that you can't talk about a political candidate in this way, 60 or 90 days before an election?
That's right, yeah. And actually, I think that goes to kind of an interesting point that we haven't really touched on yet, which is we've been talking about people pooling their money to speak explicitly for or against a particular candidate, but the federal laws are actually much broader than that, and we saw that in Citizens United. This is a concept called electioneering communications. Again, it's jargon. That the campaign finance system is full of jargon. But that basically means that for a group like Citizens United, which was a nonprofit group, they were categorically barred from making a video, publicizing a video about a very powerful politician during a set period leading up to an election.
Yeah, and the Citizens United, of course, famously in 2010, or the Supreme Court famously in 2010 said that this sort of restriction on speech surrounding election was unconstitutional.
That's exactly right. It's a controversial decision, obviously, but the principles really shouldn't be that controversial. I mean, we're talking about whether an entity can be prevented by law from talking about a political candidate, and the answer to that should obviously be that under the First Amendment they can't be.
Yeah. So as I was going to get to this earlier, but state laws are different. Yeah, state laws. Sort of the Wild West in this case. Every state has different laws regulating political speech within its territory. Some states have no laws in certain areas, like I believe Oregon, for example, has no limits on contributions to political candidates. I believe Missouri, and we're in Virginia right now, Virginia might have the same. same thing. So what do you see at the state level as far as regulations of political speech goes?
Right, well, the state regulation's interesting because of the diversity of laws. I mean, as you mentioned, that there are states where there are no limits on contributions. Even before Citizens United said that corporations can't be barred from engaging in independent expenditures, from explicitly advocating for or against a candidate, you had, I think, almost half of the states already said that corporations could do that anyway under state law, and that the sky didn't fall. What makes state law regulations so challenging, though, I think, is that in many cases they simply kind of cannibalize bits and pieces of the federal system and kind of put them together in a mishmash at the state level. And when we're talking about state campaigns or even local campaigns, which in a number of jurisdictions the laws drop down to that granular of a level, the candidates aren't as legally sophisticated. They don't have these great war chests that federal candidates might have. And yet, at the same time, they're oftentimes being subjected to the same kinds of very elaborate, complex legal regimes that they're being expected to comply with.
So how does this bear out in reality? So the Institute for Justice is a public interest law firm. You mentioned before that it participated in this Speech Now case. What are some other cases that you're taking right now at the state or federal level that illustrate how these campaign finance regulations work out in practice?
So we are currently litigating two cases in Colorado involving Colorado's state campaign finance laws. And I think that they both really demonstrate how these laws can just chill ordinary people from talking about ordinary issues. So one of them involves a woman called Tammy Holland. She lives in a small town outside of Denver. She cares deeply about her child's education. So a couple of years ago, she took out a number of ads in her local newspaper. It's a weekly newspaper, basically criticizing Common Core issues. And at one point, she runs an ad about a month or so before the local school board election, not taking a position on any particular candidate, but saying, this election's coming up, telling her neighbors to educate themselves about all the candidates, cast an informed ballot. She ended up getting sued 2 times by members of the school administration who took offense at what they perceived as a veiled criticism and wanted to force her to apologize. And that's kind of a unique facet of Colorado's law, which is that you have this incredibly complicated system of campaign finance regulation, and literally any person can act as a speech vigilante and file a campaign finance complaint and prosecute anybody else alleging any violation of these state laws.
And when these people have these complaints filed against them because they're in violation of a state's campaign finance law, I mean, are these expensive things to sort out on behalf of the defendant, so to speak, in these cases?
Absolutely. I mean, there's an enormous pressure to hire a lawyer. I mean, Tammy Holland's not a campaign finance expert. Most people who end up being sued, especially at the state level, aren't campaign finance experts. They're campaign treasurers or often volunteers. These aren't, legally sophisticated people. There's no reason for them to be. So they get a complaint in the mail saying that you've had essentially this legal proceeding instituted against you, oftentimes by your political opponent. You're going to lawyer up, and that costs money. And in fact, in Colorado, and I'm just returning to Colorado because I'm most familiar with it, and also because I think it just exemplifies just how badly campaign finance laws can go wrong. But you see these enforcement systems being used explicitly to try to suppress political speech, to try to shake people down for money. So in a very real sense, these laws, campaign finance laws, which are designed in theory to combat corruption, are themselves becoming a tool for speech suppression and corruption itself.
When the legislators created these laws, was this the intention, do you think?
I think it cannot have been the intention. So in Colorado, just as a caveat, these laws were passed by referendum. So a majority or a supermajority of the Colorado population voted these laws, in many cases, into the state constitution itself. So you have all of these unexpected consequences 10 or 15 years later, and it's very hard to address them except through litigation, which is why we brought, in that case, a federal court action challenging this really abuse-prone enforcement system.
I have to think, I'm thinking in my mind right now, of parallels between these campaign finance laws in Colorado, for example, and also just libel laws that anti-SLAPP statutes were put in place in many states to fight against. The idea being that, defamation law here in the United States, it's really hard for a plaintiff to prevail. But if you are a citizen and there was another citizen or maybe a newspaper or news outlet that's critical of you, you don't like that, and you don't want to fight it out in the marketplace ideas, but you rather fight it out in the court of law, you have this vehicle through defamation law where you can just make the process the punishment. the idea that you file a lawsuit, they have to lawyer up, spend money to do it. And while you might not prevail, you will sort of screw them over, taking time and money away. And so you have states that pass anti-SLAPP laws. SLAPP meaning, I think, it's strategic litigation against public participation. It sounds like, in this case, Tammy Holland, I believe her name was, is trying to participate publicly in the most basic way and was prevented from doing that, as a result of, I don't know, I can't speak to whether these lawsuits are frivolous or not, but I see the parallel there. Is that...
I think that's a perfect analogy. I mean, Colorado's example is kind of a perfect example of what happens when the First Amendment isn't forefront in the minds of the people who are passing laws that really apply only to core First Amendment activity. Just to give one example, we have this a guy in Colorado who in the past few years has filed between, I think, 60 and 70 of these campaign finance complaints. And he's done so with the avowed mission of waging what he calls political guerrilla legal warfare against disfavored viewpoints.
Are those his actual words?
That's a quote. The political guerrilla legal warfare part. Yeah. So it's obviously a tool for speech suppression, and without safeguards that honor people's First Amendment rights, it will obviously be very tempting for people to use this tool rather than debate someone who they disagree with on the merits.
Mm-hmm. And what are some of these laws that actually? So we have people like this man who files 60 complaints, for violations against campaign. What are some of these laws? I mean, I believe I recall some IJ cases, and during my time at IJ, I helped work on some of these cases where you have a group of citizens joining together to talk about a political issue. It might be a candidate or it might be an election, but often it could be like a ballot issue referendum. And they want to spend $200 on yard signs, and they need to form this whole apparatus to surround it, essentially creating bureaucratic red tape that, if you're just going to stand at the street corner and wave signs dealing with, a school funding measure, you might not want to deal with the BS that accompanies it.
Right. And that's what so much of campaign finance regulation is now, not just in Colorado. But just to give an example of the kinds of cases that we see in that state, I mean, there's a requirement that if you receive more than $100 in contributions from a particular person, you have to disclose not just their name and address, but also their occupation and employer. And lots of people, don't know the occupation and employer of someone who gives them $101, right? They don't realize it's a requirement. So time and again, you see people getting sued, hauled into court, required to attend court hearings, simply because they disclosed someone's name, someone's address, the amount of money they received, but they didn't say that, they work at CVS. Again, we're talking about disclosure, but really, does that added bit of information really inform anybody's vote?
And if I recall correctly, some states don't limit this sort of disclosure to just money. It can also be in-kind contributions as well. Like, let's say I'm hosting a rally on the street corner where we're going to, as I said, maybe be for or against a school funding measure. If I spend money and drive the group there, do I need to disclose that I spent $42 on gas?
Right. So in many instances, the answer to that would be yes. And we're litigating a case where the question is whether in-kind contributions can include legal services that are used to help people comply with the campaign finance laws to begin with. So you're finding people in a catch-22, and again, this just happens to be in Colorado, catch-22, where people are being subjected to campaign finance complaints. They can't afford to hire a lawyer, so they take on a pro bono lawyer, a lawyer for free, or a reduced cost lawyer. And then they end up getting sued again because someone's saying that, that's an illegal contribution of legal services. So it really is just kind of this cycle of abusive litigation, and the end result, of course, is that people just are dissuaded from engaging in political advocacy.
How do the courts wrestle with the distinction between a private citizen and a journalist in this case? So you have these campaign finance regimes set up in certain states, or it's the case of Citizens United with the federal government, where you have private citizens speaking on these issues, but you also have journalists saying the exact same thing as private citizens. Is a journalist who's writing about the school board, for example, are they required to disclose, their political activities as well if their writing is political?
Right. So the answer typically is no, and that really underscores kind of what a jigsaw regime this is. And
why is that? Is it because the laws carve out specific sections?
Well, the notion is that freedom of the press is different from freedom of speech by ordinary citizens. But that also leads us to really bizarre situations where you have these enormous media organizations that everyone seems to accept have a particular political bent. And they can spend just millions and millions of dollars talking about candidates, talking about political issues, which is great. That's their right. But at the same time, you have just ordinary citizens and people who don't happen to be part of the press, however that's defined, are either being subject to burdensome disclosure laws. Until Citizens United, they might be barred outright from talking about politics at all.
So I want to move now because we've called electioneering communications or communications about elections speech. I think you and I probably agree on this issue, but there's a lot of people who disagree on this issue and say money isn't speech. What corporations do to meddle in the elections isn't speech. It's something else. It's they also like to say that allowing for unlimited spending on elections gives all the power to the richest in society. But let's start with that first question and let's dig into some of these arguments against limited regulation on campaign speech. Why is the use of money in elections? Why should it be considered speech?
Right. Well, I think about it this way. If you want to get your message out, whatever that message is, whether it's political or not political, it's probably going to cost you money to do that. Whether you want to run a newspaper article, whether you want to publish a book, a novel, an advocacy book, and whether you want to run a political ad. So just as the government couldn't say, you're free to write a book, but you can't spend any money actually printing it, the government also can't say, you're free to talk about politics, you just can't spend any money running an ad or publishing a newspaper advertisement. It's not that money, like the currency, is speech, but it's just that if you prevent someone from speaking, from using money to speak, that in many cases is the same as preventing them from speaking at all. What
do you say then to the argument that this allows people, the richest in societies, the Charles and David Kochs of the world, undue influence in the elections? The idea that their voices, because they have more money, are heard more loudly and that they can, quote unquote, buy an election.
Right. So we hear a lot that allowing for money in speech, allowing for unfettered political discourse somehow leads to people buying elections. But what are we actually talking about? We're talking about people speaking about politics, and the concern, it seems, is that what they say might persuade people enough that it affects how they cast their vote. That's precisely what the First Amendment is meant to protect. We shouldn't be scared of speech because it might persuade someone. We should protect speech because it might persuade someone.
And we should have mentioned this earlier, but it's important to note that the courts have drawn distinctions between spending money in support of a politician and giving money to a politician to do a certain thing, correct?
That's right. So both activities have certain First Amendment protection, but the Supreme Court's kind of drawn this very jagged line between contributions, between giving money to a candidate, and between expenditures, which is going out and spending your own money on a political ad, or in Tammy Holland's case, like a newspaper advertisement. The thinking being that giving money to a politician does enjoy First Amendment protections to a degree because you're essentially publicly associating yourself with that candidate's views. That's First Amendment activity. But for better or for worse, the court said that that's somehow less First Amendment-y than actually going out and speaking directly.
What about the quid pro quo thing that I mentioned, though? The idea that I am voter X and I give politician Y a Lamborghini. Is that political speech?
Right. Well, so the main
with the hope that politician will then pass a law that supports my business or.
Right. So that sounds shady, but it's also
can't afford a Lamborghini, so I'm not going to go out and do that.
Right. But it's also almost certainly illegal under existing bribery statutes. Right.
So that's a bribe.
Well, that hypothetical sounds a lot like a bribe to me. Yeah.
And that's not what we're talking about here.
Right. And we're not even talking about you going out and giving money to your buddy, the politician. We're talking about giving money to a political campaign so that campaign can advance a political message that you agree with.
Mm-hmm. Okay. So let's talk then about arguments in favor of disclosure. There's a popular argument that says that if we disclose who's participating in an election through contributions to a candidate or to a PAC or to even a 501c4 group, that we are creating information for other voters to find and then base their votes on that. The idea being that if I know who contributes to the Sierra Club's political activities, then I can derive some information for that, because if they're all environmental activists, I know that Sierra Club's support of this candidate is probably a good thing. What do you say to the idea that disclosure creates more information for the voter and is therefore a valuable thing in the marketplace of ideas?
Right. So a couple of points. I mean, the classic argument for disclosure is, right, the Justice Brandeis quote that, sunlight is the best of disinfectants. But there are a couple of problems with that. The first, that the notion that disclosure is just a general good might be true or false, but that doesn't necessarily mean that it's a legitimate government interest to force people to disclose their personal information as the price of admission, as the price of engaging in political advocacy. If listeners think that the identity of a speaker's supporters is relevant, then they're free, of course, to discount that speech if the person hasn't been forthcoming about who's supporting them. But that doesn't, to my mind, it doesn't translate to the kinds of really expansive disclosure regimes that are imposed on people by law.
So has there been any evidence, if that's an argument cited, that the average voter actually goes and spends a meaningful amount of time looking at who's donating to a PAC or to contributing to a candidate? Is that something they would base their votes on? Or is that some, in the ideal world, we would have this super well-informed voter who would take that information into account?
Right. I mean, I think it's highly unlikely that really anyone, not many people, are going onto state or the FEC donor rolls and scrolling through thousands of cells looking at who gave $200 to who. The thinking, I guess, is that the press does that, and that you have news reports that kind of distill this information. But again, it's not all that clear that this information has much, if anything, to do with the voter's ultimate decision. In large part, we're taking it on faith, and we're just accepting that people think as a general matter that disclosure is good, that we like disclosure. And based on these kinds of amorphous ideas that this is somehow a good thing, that's translated into using the coercive power of government to really intrude on people's First Amendment rights.
Now, so we've talked a little bit about individual contributions, and whether money is speech. We've talked a little bit about disclosure. Let's talk about what actually happens in practice. Do you think it is even possible to buy a vote? Like, do you believe that it is possible for Charles Koch to spend so much money that he then essentially forces someone to vote for his candidate of choice? Or is there something that stands between Charles Koch's spending, or, as we've talked about here, public advocacy speaking, and the actual election of a candidate?
Right. Well, the main thing that stands between those two things is the autonomy and the decision-making power of each individual voter. Again, when we talk about buying elections, we're talking about people listening to an ad, seeing an ad, and either rolling their eyes if they don't find it persuasive, or maybe they think, that this ad makes a good point. Maybe I should look into this candidate more, and they find something persuasive. I mean, again, that seems like a cardinal good that the First Amendment is supposed to protect, and whether more ads might make more speech might make a particular ad more persuasive, I don't know. But ultimately, I don't think we should be afraid that we're having too much speech about politics.
So would you say then that we don't spend enough money on politics? Well, I'm speaking to you personally, Sam Gedge, not of course, and speaking for the Institute for Justice here. But if I mean, it goes without saying that if you believe that money is speech, or that the spending of money on political advocacy is speech or represents speech, then more money spent on that is a good thing if you believe more speech is good for society as a whole, right?
Well, I think as a general matter that sounds reasonable. Not that we should necessarily be, of course, not forcing people to talk about politics, yeah. But if people want to spend millions of dollars saying that candidate X is a great guy or candidate Y is a bad guy, why are we afraid of that? Let them do it. If you don't want to listen to him, turn the channel. Yeah.
Now, the United States does have some unique laws. I don't know that they're unique laws, but it does prohibit foreigners from spending money on our elections. Am I correct?
That's right. So part of the federal campaign finance law is that foreign nationals cannot engage in independent expenditures. They can't make contributions to federal candidates. I think that also drops down to the state level as well. More troubling, though, is that these laws also extend to people, foreigners who are living in the United States legally, green card holders, for example. Right. And just as a general matter, people in the United States who are green card holders, for instance, are entitled to full First Amendment protection, full constitutional protection. Nonetheless, though, the courts have held that these folks can be singled out and really barred from engaging in certain parts of the political process.
So that's interesting, because the courts, in recent history is that if green card holders have full First Amendment protections, and the courts are holding that speech spent on elections is protected by the First Amendment, you would seem to think that they would have this right to participate.
Right.
It's a special carve out for now green holders just dealing with political speech.
Essentially, yes. There was a case a few years ago here in D.C. where I think it was a green card holder who was originally from Canada. I think she worked at a big law firm up in New York. Wanted, I think, to distribute pamphlets advocating about a federal campaign. The district court said, well, it's constitutional for the federal government to prevent you from doing that. And the Supreme Court either summarily affirmed it or declined to hear the case at all.
Is there any evidence that candidates who spend more money generally win elections? Or you might not know this off the top of your head. Or is it, because I've heard the argument that, the candidate who spends the most money is going to win an election, or the candidate that has receives the most campaign contribution or has the biggest war chest is going to win. But is that causal connection confused by the fact that most candidates who have more money are incumbents who have the name recognition to win the elections already, or have an upper hand in the elections already?
Right. So I'm not sure if there is a correlation, and to the extent there is, I think there's probably a lot of different factors that go into it. But one thing I'll note, though, is that a study was done by the California Fair Political Practices Commission probably about 10 years ago, maybe a little bit longer.
This presumably is a reformer group of some.
Yeah, it's the group that essentially enforces California's campaign.
We've been focusing a lot on Colorado right now, so
going a little bit further west over to California. And this study talked about all of these massive spenders when it comes to independent advocacy in California. But when you took a closer look, it turns out that many of the campaigns that these big spenders were spending on ended up losing, which suggests that maybe if you have the folks behind Walmart spending to advocate for your campaign, that's not a slam dunk that you're going to end up winning.
Yeah. Is there any evidence that in these states where, because one of the main arguments, and we should probably say this because we didn't say it earlier, for these campaign finance regulations is corruption. They root out corruption. The more money you have in politics, the more it corrupts a politician's motives and prevents them from having a public-spirited term of public service. But is there any evidence in these states that don't have contribution limits, like Oregon or Missouri or Virginia, that those states are more corrupt?
I don't think, not that I'm aware of. I mean, Virginia obviously had a kind of a big issue with their governor receiving gifts a few years ago.
Yeah.
But it just as a broader matter, no. And I think that really undercuts the notion that there is this link between robust political participation, whether it's through independent advocacy or giving contributions to candidates, and corruption. And I think the way that regulators get around that is by saying that this isn't just to combat corruption, but it's to combat the appearance of corruption. That's pretty amorphous. I mean, what's the appearance of corruption? So in the past, you've seen cases where governments say, we don't actually have proof that contributions in our state have done anything to corrupt anybody. But we took this survey where a bunch of people think that it would. And the courts have said, well, that sounds like the appearance of corruption to us. That's good enough.
And so the argument there then is that people need to have faith in their government, and even if they deeply distrust their government and that distrust is unfounded with any empirical evidence, we still need to consider that.
Right. That's exactly right.
But in this case, it's at the cost of people's ability to speak out.
Right. And that's what makes campaign finance laws such an anomaly when it comes to First Amendment doctrine more broadly, because the First Amendment rights are among the most traditionally highly protected of the rights embodied in the Bill of Rights. And And typically when the government wants to infringe your First Amendment rights, it's not enough that they just speculate about a harm to be avoided. They have to actually come into court. And they carry the burden of proof to demonstrate with admissible evidence that these laws are actually serving a government interest. But time and again in the campaign finance sphere, it's almost good enough for government work. You're talking about the appearance of corruption. That's basically speculation in many cases.
So we were talking just now about whether money can win someone an election. We just got done with an election, and Donald Trump won. Of course, he's been in office now for something like 60 plus days, and he was vastly outspent by Hillary Clinton. You've seen examples of this previously with Eric Cantor, for example, who was a majority leader of Virginia, losing to an upstart Tea Party candidate in the state, despite Eric Cantor being a prolific fundraiser. So that I think is a data point that it would be pretty convincing, this idea that what stands between a messenger with a large war chest and the winning of the election is this voter. And if how they want to spend their war chests doesn't convince the voter, then you're still going to lose an election. Hillary Clinton can spend as much money as she wants, but she's not convincing, for example, rural America.
Right.
Her message matters.
Right, and I think examples like that do really drive home that there's not this correlation. Voters aren't just automatons, and if they see enough ads or expensive enough ads, they're going to go out and cast their ballot the way that these like dark money groups want them to do it. Many people probably have made up their minds before they see the ads at all.
Yeah.
To the extent they haven't, people are smart. They can figure things out. They know if someone's a phony or someone's not a phony in the ideal case. And and in any event, they of course have the ability to determine who they think will serve their interests and the country's interests best.
Yeah. Speaking of Donald Trump, let's move on now to how the campaign finance landscape might change in the future. Campaign finance, while it was a top of the mind issue in 2010 after Citizens United, and for a couple of years after that, of course, you had Obama famously chastise Supreme Court justices during the State of the Union address. It's not a top of the mind issue right now, where immigration and healthcare reform and tax issues are sort of dominating the headlines. But Donald Trump himself has said that he's in favor of campaign finance reform, that there's too much money in politics. Is there any concern that, the gains made from the free speech side on these issues will be rolled back under his administration? And talk a little bit about Neil Gorsuch, because his opinions on these matters sort of diverge with Donald Trump's, so far as we know.
Right. So President Trump, I think, at least once has suggested that he disagreed with the Citizens United decision.
Mm-hmm.
That, of course, is cause for concern. Hillary Clinton also disagreed with it. I mean, she was the subject of the movie at issue there. At the same time, though, it seems unlikely that a Supreme Court would just overrule Citizens United. The reason being that I can't think of any case where the Supreme Court has overruled a precedent in a way that restricts someone's constitutional rights. We see the Supreme Court expand rights all the time, but very rarely do they take a precedent that protected First Amendment rights more strongly and hemmed it in to protect First Amendment rights less solicitously, which essentially would be what would happen if Citizens United were overruled.
And was Citizens United, you'll have to refresh my memory on this, was that a 5-4 decision? Was it a divided? And what were some of the dissenting arguments there then that might point to how you could restrict these political speech in the future? Right.
So Justice Stevens wrote an incredibly long dissenting opinion, which I have to admit I haven't read recently. It's like about 100 pages long.
This isn't a test.
But the arguments are what we've discussed. That there's this overwhelming interest in people having faith in our government, and that in that case, just letting other people or other entities talk about politics was somehow so corrosive to the system itself. That justifies banning speech during certain kind of no free speech windows, 60 days before an election, for example. Again, I think the longer that Citizens United remains on the books, and we see that the sky isn't falling when there's more political ads, the harder it will be to plausibly argue that First Amendment rights should be dialed back by overruling that decision.
And the Roberts Court has, for its almost entire term, been good on, from a free speech perspective, on campaign finance issues.
That's right. I mean, we had the McCutcheon case, which involved contributions, aggregate.
2014.
Exactly, yeah. Another 5-4 decision, or 4-4-1 decision, I guess, more technically. So yeah, I think there's reasons to be optimistic, at least when it comes to issues about whether you have the right to speak about politics. When it comes to disclosure laws, paradoxically, maybe the Supreme Court's been a lot less concerned with the chilling effects that requiring people to disclose their home address and their names and their political affiliations might have.
So by way of closing, then, you're optimistic that things will keep moving in the direction that they are moving right now, at least as far as political speech goes. Disclosure being a separate issue.
Right. I think that's a fair characterization. Yeah.
All right. I know you're a busy man and you've got a meeting here coming up, but just by way of closing, is there anything you can recommend to our listeners if they're interested in learning more about these issues? A book, an article, a movie?
Sure. Well, one book that springs to mind, it's pretty old now, I think maybe 10 or 15 years, is a book by Brad Smith called Unfree Speech. Mr. Smith was a commissioner, I think the chair of the Federal Election Commission a while back. He provides a pretty compelling critique of many of the justifications that underpin campaign finance laws.
Yeah, and he was a founder, I believe, of the Center for Competitive Politics, another organization that works on these issues, and I think partnered with the Institute for Justice on Speech Now, if I'm
exactly
not mistaken.
Right.
All right. Well, Sam, I appreciate you coming on. I hopefully for our listeners, we've worked through this complicated issue of campaign finance methodically, and that we know more now than we did 43 minutes ago. Sam, thank you so much.
All right, thank you.
That was attorney Sam Gedge from the Institute for Justice. To learn more about Sam and the Institute for Justice, you can visit ij.org. Again, that is ij.org. And to learn more about the history of campaign finance regulation in the United States, if you can't get enough, check out FIRE's First Amendment Library, where we have a detailed timeline of important moments in the history of campaign finance. You can find that timeline over at firstamendmentlibrary.com. That is firstamendmentlibrary.com. And you can click on timelines on the right-hand side to find the campaign finance timeline specifically. This podcast is hosted, produced, and recorded by me, Nico Perino, and edited by Aaron Reese. To learn more about So to Speak, you can follow us on Twitter at twitter.com/freespeechtalk, or like us on Facebook at facebook.com/so-to-speak-podcast. You can also email us feedback at so-to-speak@thefire.org, or leave a voicemail with a question for a future show at 215-315-0100. Again, that is 215-315-0100. And until next time, thanks everyone again for listening.